Investors into Ireland now face an additional layer of regulatory complexity. Ireland's new investment screening regime recently became law and is anticipated to come into force in Q2 2024. The Act introduces a mandatory and suspensory notification obligation for transactions involving the acquisition of an asset or an undertaking in the state by a third country acquirer where certain criteria are met. A third country is essentially any country outside the EEA and Switzerland. The Act casts a wide net. It applies where the value of the transaction is at least €2 million and the transaction relates to one or more of the broadly defined critical sectors under the EU screening regulation. The acquisition of a minority non-controlling interest of at least 25% of shares or voting rights may also be within scope. The silver lining for investors is that internal reorganizations do not need to be notified. The new regime is separate from the existing merger control rules. It is expected that certain transactions will need to be notified under both regimes. This has the potential to create significant deal complexity and add timelines. Larger clients will also need to consider whether the EU's new foreign subsidies regulation applies to them. The FSR introduces another mandatory notification obligation where certain financial thresholds are met in respect of EU turnover and foreign financial contributions. We are advising a large number of clients, in particular those based in the UK and the US, on the potential impact of this new legislation on their transactions. Our advice enables clients to plan ahead to ensure that the transaction process moves as smoothly as possible.